Hello, I'm attorney Chris Morgan. If you have a child with special needs, you've likely become accustomed to being told what's best for your child by people, even professionals, who don't really have any clue about your child's specific needs or experiences. You will also have experienced the frustration of getting different answers to the same question from different people who all claim to have a one right answer. I want you to know that at Morgan Law, we know that your child's best advocate is you. You are the expert here. We are not here to talk over you or to pressure you. We are here to share what we know first, and then, and only then, if you feel it's the right fit for your child and your family, we would love to help. Generally speaking, government benefits are needs-based. This means the person getting the benefit actually needs them, rather than just simply having a disability diagnosis. The government will actually look at any and all available resources before granting benefits, and then will require subsequent updates on how much money a disabled person has available to them. Basically, this boils down to the reality that if your child is on disability benefits, they cannot have more than a tiny amount of money or other assets titled in their own name. If your child were to get a large sum of money, the government would require strict management of the funds. At your child's death, any remaining funds go to the government. This is why it is usually not a good idea to have property or money titled in the name of a person who is eligible for disability benefits. This makes it tricky when we are planning for an inheritance, because the last thing a person receiving government benefits needs is a big check from your estate. Here's where a properly drafted supplemental needs trust can be helpful. This is also sometimes referred to as a third-party trust. A trust is a management agreement between a donor and a manager called the trustee. In the case of a supplemental needs trust, you are donating funds to be managed in trust for your disabled child. That donation does not happen today. It typically happens at your death. The advantage here is that while the funds can be used to support your child, legally, they are not your child's funds, so they will not affect their disability benefits. Furthermore, because the funds are not legally titled in your child's name, whatever is left in your supplemental needs trust at the death of your child will not go to the government, but instead onto your remaining family members. A self-serving word of caution. Supplemental needs trusts are very powerful tools, but they need to be set up by someone like me who actually knows how to create them. I am called all the time to deal with trusts where someone threw in some language mentioning disability and thought it would do the trick, when in fact, it actually made the situation worse. Please feel free to reach out if you'd like more information. I do not charge to chat, ever, whether it's on the phone or in my office. If you have any questions about supplemental needs trusts or estate planning in general, I'm here to help. Thank you.